everyone, today we will do legal dictation exercise number 5 for High Court and Civil Court. You can get the PDF from description box. So ready? Start. Power of Supreme Court to transfer suits etc. on the application of a party and after notice to the parties and after hearing such of them as desire to be heard, the Supreme Court may at any stage, if satisfied that an order under this section is expedient for the ends of justice, direct that any suit, appeal, or other proceedings be transferred from a high court or any other civil court in one state to a high court and other civil court in any other state. Transfer of suits under section 24 and 25 have been considered by this court in various decisions. In Menka Sanjay Gandhi versus Rani Jethmalani 1979 SCC 167, this court stated SCC para 169 para 2. Assurance of a fair trial is the first imperative of the dispensation of justice and the central criterion for the court to consider when a motion for transfer is made is not the hypersensitivity or relative convenience of a party or easy availability of legal services or like many grievances. Something more substantial, more compelling, more imperiling from the point of view of public justice and its attended environment, its necessities, if the courts is the exercise its power of transfer. This is the cardinal principle, although the circumstances may be myriad and vary from case to case. Emphasis supplied. Similarly, in Subramaniam Swamy, Dr. versus Ramakrishnan Hegde, 1990, SCC 4 dealing with power of this court to transfer a case under section 25 of the code, A.M. Ahmadi G. as his lordship then was stated SCC para 9 para 8. Under the old section, the state government was empowered to transfer a suit, appeal, or other proceedings pending in the High Court of that state to any other High Court on receipt of a report from the judge trying or hearing the suit that there existed reasonable grounds for such transfer, provided that the state government of the state in which the other high court had its principal seat consented to the transfer. The present section 25 confers the power of transfer on the Supreme Court and is of wider amplitude. Under the present provision of the Supreme Court is empowered at any stage to transfer any suit, appeal, or other proceedings from a high court and other civil court in one state to a high court or other civil court of another state if it is satisfied that such an order is expedient for the ends of justice. The cardinal principle for the exercise of power under this section is that the ends of justice demand the transfer of the suit, appeal, or other proceedings. The question of expediency would depend on the facts and circumstance of each case, but the paramount consideration for the exercise of power must be to meet the ends of justice. It is true that if more than one court has jurisdiction under the code to try the suit, the plaintiff, as dominus litis, has a right to choose the court, and the defendant cannot demand that the suit be tried in any particular court convenient to him. The mere convenience of the parties, one of them, may not be enough for the exercise of power, but it must also be shown that trial in the chosen forum will result in denial of justice. Cases are not unknown where a party seeking justice chooses a forum most inconvenient to the adversary with a view of depriving that party of a fair trial. Parliament has therefore invested this court with the discretion to transfer the case from one court to another if that is considered expedient to meet the ends of justice. Words of wide amplitude for the ends of justice have been advisedly used to leave the matter to discretion of the apex court, as it is not possible to conceive of all situations or justifying the exercise of power. But the paramount consideration must be to see that the justice according to law is done. If it is for achieving the transfer of the case is imperative, there should be no hesitation to transfer the case even if it is likely to cause some inconvenience to the plaintiff.